Canadian Bankruptcy Discharge, critical illness insurance in a Canadian bankruptcy. Many times during the administration of a Canadian bankruptcy, the licensed insolvency trustee comes across a novel issue. The decision of A.R. Robertson, a registrar in bankruptcy in Calgary, Alberta, in the bankruptcy discharge application of Shirley Rose Cook has such an issue within it. The issue that came before the court was, what happens to a critical illness benefit payment for the undischarged bankrupt? Does it go to the trustee, or is the undischarged bankrupt debtor able to keep it? Registrar Robertson described this case as an interesting application for bankruptcy discharge. Ms. Cook is 62 years old. She filed for bankruptcy on April 12, 2016. The issue to be decided is whether a critical illness benefit payment she obtained in the amount of $25,000 forms part of her assets which fall to the trustee. The trustee's position was that it is an asset of the bankruptcy estate and Ms. Cook's creditors are entitled to it. In March 2016, Ms. Cook was diagnosed with breast cancer. She went through surgery and had radiation treatments until July 2016. Prior to her medical diagnosis, she worked full-time as a healthcare worker. She stopped working in March 2016 as a result of her diagnosis and need to undergo surgery and radiation. She returned to part-time work at her former employer in about August 2016. Her evidence was that at the time that she left her full-time work, her employer informed her she had the critical illness benefit policy and that she should apply under it. Apparently, she was unaware of this policy as being part of her benefits package. She applied for the benefit payment. When she made her assignment in bankruptcy, she did not divulge the critical illness benefit application to the trustee. She advised the court that she did not have any type of certainty that she would receive the benefit. Eventually, she did, in January 2017. When she did, she advised her trustee. The trustee took the view that the critical illness benefit payment should be paid to the trustee. It was very clear from the evidence that had she known she was going to get a $25,000 insurance payment from the insurance company, she would likely not have entered bankruptcy. Had she divulged the benefit application to the trustee may very well have recommended she not go bankrupt. The trustee desires that Ms. Cook pay the amount of $20,000 as a condition of her discharge. The trustee states that in dealing with this critical illness benefit issue, including research, its fee now approximates that amount. Ms. Cook's legal counsel referred to the registrar the facts under S.173 of the BIA that could lead to an absolute discharge from bankruptcy not being granted. Her legal counsel indicated that none of the factors that would allow for a conditional, suspended or refused discharge apply in this matter. The registrar correctly pointed out that none of the exemptions in the BIA mention a critical illness benefit payment. The registrar could also not find a precedent exactly on point. The closest cases the registrar could find were those of when the undischarged bankrupt suffered an injury in a motor vehicle accident and had a claim for pain and suffering. The registrar stated that he sees no sensible distinction why a tort-based damages insurance claim for pain and suffering would be dealt with in a different way than a contract-based insurance policy for the pain and suffering Ms. Cook had. The registrar decided that the critical illness benefit payment did not create property designated to the trustee. He also stated that Ms. Cook was not required to pay it, or any other amount, to the trustee. The registrar directed that. Although the registrar did not explicitly state it in his judgment, the implication certainly is that Ms. Cook received an absolute discharge from bankruptcy. The trustee should bring on the application for the trustee's discharge. The trustee keep the registrar's comments as to the trustee should have brought on a motion on the critical illness benefit issue earlier when submitting its dockets to have its fee and costs taxed by the court. I hope that none of us ever suffer from such a critical illness. Do you have too much debt, or debt that you can't repay because life got in your way? Call us today for your free consultation.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting over, starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.